Me gustaría llamar, por favor, al estrado a nuestro moderador José Antonio Arochi, a Jeffrey Greenbaum, a Damaso Pardo, a Valdir Rocha y a Magali García, por favor. Dirige las áreas de tecnologías de la información y de la comunicación y de derecho de la publicidad. Él es también vicepresidente para las Américas de la Global Advertising Lawyers Alliance de Gala. Sobre nuestros panelistas, bueno, pues tenemos a Jeffrey Greenbaum. Él estudió Derecho en la Universidad de Columbia. Él es socio director de Frankfurt Ernest Klein & Sells. Él es uno de los abogados más importantes de derecho de la publicidad en Estados Unidos. Él asesora a publicistas, agencias de publicidad, compañías productoras y entretenimiento en temas relacionados con publicidad y propiedad intelectual. Es presidente de la Global Advertising Lawyers Alliance Gala. Damaso Pardo, él estudió Derecho en la Universidad Católica Argentina, Santa María de los Buenos Aires, y cuenta con el grado de maestría en propiedad intelectual por la Escuela de Derecho Franklin Pierce de la Universidad de New Hampshire. Él es actualmente socio de la firma Rocha y Funch de Rioja en el Departamento de Propiedad Intelectual, Privacidad, Nuevas Tecnologías y Publicidad Legal. Y él asesora y litiga en asuntos relacionados con la propiedad intelectual, marcas, patentes, diseños industriales, publicidad, privacidad, protección de datos e Internet. Y él fue presidente del Instituto Nacional de la Propiedad Intelectual de la República Argentina. Valdir Rocha, él es socio senior de las áreas de propiedad intelectual y publicidad de la firma Beirano Advogados. Él forma parte de los consejos directivos de la Asociación Brasileña de la Propiedad Intelectual, API, y de la Asociación Brasileña de Agentes de Propiedad Industrial. Él ha sido vicepresidente global y regional de la Global Advertising Lawyers Alliance también, Gala. Y Magali García. Ella es abogada por la Universidad de Lima y cuenta con el máster en Derecho de la Propiedad Intelectual y competencia por la Pontificia Universidad Católica del Perú. Ella es socia fundadora del estudio Allende y García Abogados. Es abogada experta en temas de propiedad intelectual, competencia y publicidad. Es catedrática de la Universidad Peruana de Ciencias Aplicadas de la UPC y da el curso de Legislación de las Comunicaciones. Gracias por su paciencia al oír estas interesantes biografías de nuestro panel. Les pido un aplauso para ellos para iniciar el panel. Gracias.
Hola a todos, ¿cómo están? Bueno, antes que nada este panel va a ser en español y en inglés. Solamente para que sepan, por si tienen que hacer todo el tema de la traducción. Porque Jeff lo va a hacer en inglés, Valdir en inglés, Damaso y Magali en español. Pero va a ser diferente la interacción de este panel. Al final vamos a hablar de diferentes conceptos y empezaremos con Magali, después con Jeff, después con Valdir y al final Damaso, y yo hablaré un poco de México, ¿no? Entonces, Jeff, thank you very much for being here. Magali, gracias por estar aquí. Valdir, thank you very much. So, like many of you know, in Mexico, particularly, there's no influencers like legislation. We don't have anything. Everything is a contract. We don't have anything. So today we have people from the United States, from Peru, from Brazil, and from Argentina to tell us a little bit about what's happening in the jurisdictions. I take a lot what happens in Peru as Latin America, because in Peru there is guidelines from Indecopi, which is the Peruvian PTO, for influencers that we don't have in Mexico. Amazingly, the economics in Mexico. ¿Me escuchan? The economics in Mexico obviously are much bigger than in Peru, so it's amazing how a legislation like Mexico doesn't have this type of regulations. So at the end, Peru, who are, Magali, o quiénes son las autoridades competentes en el Perú?
Hola, José. Ay, por Dios. Bueno, en Perú, probablemente muchos saben, tenemos una agencia de competencia que también es nuestra oficina de marcas y patentes, abarca todo lo que es propiedad intelectual y competencia. El nombre es Indecopy. Las siglas corresponden a Instituto Nacional de Defensa de la Competencia y de la Propiedad Intelectual. Es como una gran agencia del mercado. Dentro de Indecopy existe la Comisión de Competencia Desleal. Y la Comisión de Competencia Desleal es la encargada de regular el tema de unfair competition y de publicidad. Entonces, en primera instancia, todo lo que es temas de publicidad, incluyendo el tema de influencers que hacen publicidad, lo va a resolver administrativamente la Comisión de Competencia Desleal del Indecopy. Todos los procesos administrativos tienen la opción de irse al contencioso administrativo a nivel judicial. Entonces, existe también la posibilidad de que el proceso llegue a instancias judiciales, irían de frente en un contencioso administrativo a la Corte Superior y en apelación a la Corte Suprema. Y acaba ahí.
Perfecto, Magali, muchas gracias. So, Jeff, for the United States, I think the United States is one of the jurisdictions that all of us have to have it as an example, because actually the FTC, which is the authority, the competent authority that regulates many of these matters, enforces the day-by-day of these cases. But tell us a little bit about the legislation in the United States, please.
Well, I think the thing I just want to say as we start off this panel is to talk about the fact that in the United States, the law in this area is so incredibly developed. We have general laws in both federal law, state law, local law that govern false advertising, but we also have very specific standards related to the use of endorsers and influencers as well. And as a result of that, this is something that we have been thinking about now for literally in detail for nearly 20 years. So there's a tremendous amount of guidance that gets down to a very, very granular level, which we'll talk about later on. The other thing that's important to understand is that, like Jose said, the Federal Trade Commission, which is the main federal authority in the United States that enforces the nation's consumer protection laws, is out there enforcing these laws, but so are many others as well. There's state attorneys general, there's other consumer protection authorities, consumers can bring actions, competitors can bring actions. We have a very effective self-regulatory body in the United States as well. So, the real point to start off this conversation with is in the United States, this is considered to be a very, very big issue that there's a lot of law that's covering, and it's really being looked at from many, many different angles.
Thank you very much, Jeff. Damaso, ¿nos puedes platicar un poquito de lo que pasa en Argentina en relación a la legislación de los influencers y las plataformas?
Sí, en Argentina nosotros no tenemos una ley de publicidad orgánica como tiene España, por ejemplo, y tenemos diferentes normas diseminadas en distintos cuerpos legales. Por un lado tenemos la ley de lealtad comercial, ¿no es cierto?, que ha sido recientemente modificada por el decreto 274 del 2019. Tenemos lo que siempre es muy relevante, la ley de defensa del consumidor, que tiene normas que atañen específicamente a la publicidad y cómo debe ser la publicidad, y que el contenido de la oferta está, digamos, incorporado en la obligación de la empresa que publicita e indirectamente en ese influencer. Y tenemos, por otro lado, un régimen muy fuerte y de mucha tradición que heredamos de Inglaterra de self-regulation. El CONAR, que es el organismo de autorregulación, es muy relevante, tiene mucho prestigio y las principales empresas y anunciantes son miembros y normalmente acatan las normas y los guidelines y las recomendaciones del CONAR.
Muchas gracias, Damaso. Well, that's for me. I'm sorry that I interrupt you. Well, in Mexico, and I'm going to speak in English, we have many authorities that regulate influencers in a way, because at the end we don't have a law that establishes matters regarding influencers, but we have Profeco, which is a Mexican Consumer Protection Agency. We have COFEPRIS, which is the Mexican FDA. At the end, why the Mexican FDA? And when I talk to my colleagues from other jurisdictions, they say, why does the FDA, the Mexican FDA, regulates publicity matters regarding different objects or materials or different. It's very regulated on medical devices, on tobacco, on alcohol. Then obviously we have the Mexican IP office, which is the INPI, which sees cases regarding unlawful competition, obviously. And at the end, it's interesting, but in Mexico, the first instance regarding litigation in IP is the Mexican PTO, just so you know. Obviously, we have Indautor with the Copyright Office and with all the reservas, which I will be speaking a little bit later. Then we have the FGR, which is the Mexican Attorney General's Office. COFECE, which is the Antitrust Commission, which is now regulating the new law on transparency regarding publicity matters. And obviously, we have civil courts for moral damages and related matters. We forgot about Brazil. I'm sorry.
But I can't talk without a slide.
I'm sorry.
Well, in Brazil, I was preceded by Susana from CONAR, who helped me talking about the Consumer Protection Code. As we were talking about the authorities, I would mention Anvisa, which is the Brazilian FDA that regulates packaging and advertising of food products and drugs. Some states have an agency called PROCON. It's also a consumer protection agency. They can include it. They can issue fines, for example, which CONAR cannot. But the successful story in Brazil, success case, is self-regulation. CONAR is very active. They've been active for over 30 years, and we're going to talk about the regulations for social media and influencers in a bit. And as regards the laws, the most important piece of legislation, I would say, is the Consumer Protection Code. IP law also applies, and most of all, the CONAR Code.
Thank you very much, Valdir. So at the end, the next step is talk about the legal framework in each of the jurisdictions, and obviously we'll start with Perú. Magali, por favor, platícanos un poquito de cómo está la regulación en Perú.
Gracias. En Perú, como les comenté, lo veía la Comisión de Competencia Desleal. Tenemos una ley específica, que es el Decreto Legislativo 1044, que abarca ambos temas, competencia desleal y publicidad, en una sola norma. Antes teníamos dos leyes, se reguló y se puso solo en una. Para estos casos, muchas veces también se cita la Ley de Protección al Consumidor. Es otra ley. Se utiliza muchísimo el Código de Ética de la CONAR. No es obligatorio, it's not mandatory, pero es un código de ética el principal regulatorio para los temas de publicidad, y existen leyes específicas en materia publicitaria para ámbitos específicos, alcohol, tobacco, food, medicines, children products, en que se tienen que respetar. Y finalmente, que era un poco el tema por el que José me dijo, Maga, el tema de Perú es súper importante. ¿Por qué? Porque tenemos una guía para influencers específica que saca el Indecopi en el año 2019, un poco novedosa. ¿Pero por qué? Porque el tema lo ameritaba. Entonces, si bien es una guía, no es una ley, se utiliza muchísimo y se ha aplicado en todos los casos que el Indecopi ha procesado en relación con publicidad de influencers.
Al final eso es un tema aquí en México, porque no puede ser que Profeco no tenga, aunque sea ciertos lineamientos relacionados a los influencers. Al final creo que la publicidad fue un boom para todos los influencers cuando empezó todo el tema de la pandemia.
Correcto.
¿No? Entonces creo que es importante que un país como Perú tenga estos lineamientos. Y te agradezco por platicarnos un poquito de esto.
Creo que en la siguiente hay un...
Ah, sí.
Sí. Como mencioné, esta guía no es una ley, pero se ha utilizado en todos los casos que ha resuelto el Indecopi en relación con influencers y que sigue procesando. Entonces, esta guía es más... A ver, es un manual, es como un instruction manual. Y, por ejemplo, tiene cosas que llaman la atención como el glosario. Entonces, te define en idioma castellano términos en inglés como son influencers, followers, unboxing, porque pues no hay una traducción para el unboxing, pero el unboxing puede generar publicidad. Te define todo lo que es canje, qué se considera canje, cuándo es influencer vía canje hace publicidad en redes. Entonces, te pone ese tipo de términos y los amplía en la guía. Específicamente, ¿qué te dice esta guía para influencers? Les dice que tienen que respetar el principio de autenticidad en la ley, es decir, ese seguidor tiene que saber que estás haciendo publicidad. No puede confundirse, no puede pensar que es una experiencia propia del influencer, tiene que saber que eso es publicidad y hay un mandato obligatorio de poner hashtag publicidad en ese reel, en ese espacio que está ocupando el influencer hablando del producto. Además, tiene que respetar el principio de legalidad, específicamente para los rubros en los que hay una ley. Por ejemplo, en bebidas alcohólicas, tiene que poner la advertencia de que las bebidas alcohólicas están prohibidas para menores de 18, de que las bebidas alcohólicas pueden causar un riesgo a la salud, etc. Tiene que respetar, por ejemplo, las normas de los bancos, los intereses, todo el tema legal para aspectos específicos tiene que ser respetado. Y específicamente la guía también dice, tienes que portarte de una manera leal y correcta en el mercado. No puedes hacer actos de discriminación y tienes que tener actos de lealtad. Es decir, lo abarca de una manera general, pero lo dice. Entonces, para terminar con el tema de esta guía, lo que estaba comentando, ha sido successful, ¿no? Ha sido importante, ha tenido alguna finalidad concreta, rescatable, sí, y mucha. Han habido cerca de 200 investigaciones a influencers peruanos. Es decir, Indecopi les abre investigación y no necesariamente eso llega a abrir un caso procesal administrativo, pero sí el hecho de que al influencer le llegue una comunicación del Indecopi diciéndole te estoy abriendo una investigación, pone las barbas en remojo, como decimos en Perú, es decir, los pone a todos alertas. Ha sido muy advertised esto, o sea, ha sido muy publicitado, ¿no? en Perú. De los 180 investigaciones preliminares que se abrieron, por lo menos 68 casos sí se abrió un proceso. Entonces, pues, especialmente los macro y mega influencers, a los que se les puede aplicar, después lo vamos a ver, unas multas inmensas, están siendo súper cuidadosos con qué es lo que hacen. También los mismos advertisers, los anunciantes que contratan a ese influencer y le pagan, tienen muchísimo cuidado porque son los preferidos del Indecopi para que Indecopi los denuncie. Muchas veces prefieren llegar al anunciante y al influencer. De acuerdo a ley, tienen responsabilidad solidaria porque consideran al influencer cuasi anunciante.
Tú dirías que hay observancia en relación a la materia, o sea, al final sí van en contra de los influencers en el día a día, porque eso aquí en México no pasa, o sea, tiene que ser un trending topic para que agarre el asunto de oficio, por ejemplo, Profeco, y de alguna forma llegue con el influencer o con la empresa. O sea, tú dices que en Perú sí existe todo este tema de ir en contra de los influencers.
Completamente, reguladísimos. Okay. Sí.
Eso ayuda mucho el tema de los lineamientos, ¿no?
Así es.
Que al final aquí no los tenemos en México. Jeff, please.
Sure. So it's so interesting to me how in Peru there is the set of non-binding guidelines that have become so influential, because that is essentially what has happened in the U.S. as well. The FTC has guides about the use of endorsers, which includes influencers and advertising, and the guides have been around for decades, but they've evolved to cover influencers as well. And when you're talking about the use of influencers and advertising, when we think about it in the U.S., we really think about three key principles. The first is that if an influencer is speaking on behalf of an advertiser, the influencer has to express their honest opinions, beliefs, and experiences. That's number one. Number two, if the influencer is talking about their experience with a product, their experience has to reflect the typical experience of the product. They can't say that the product helped them lose all this weight if the average consumer isn't going to lose that weight. And the third piece of enforcement, the third principle out of the guidance that has really been the focus of enforcement for at least the last decade, has really been this notion of connection, which is that when an influencer has a connection to an advertiser that is not reasonably expected by the audience, that connection needs to be disclosed. Those are really the three key principles. There's a lot of detailed guidance. There's a lot of examples that go into that. But ultimately, it's about tell the truth, make sure what you're saying is what the experience is that consumers will expect. And if you're speaking on behalf of an advertiser, you have to disclose that. Now, one of the really interesting things that the FTC has focused on as the use of influencer advertising has become more important is advertisers as well as other sort of players in the chain of the supply of advertisers, PR agencies, agents, ensuring that they also take responsibility for influencers as well. So one of the principles that's important for marketers, agencies, and others to understand is that under US law, the brands are just as responsible and the agencies are nearly just as responsible for influencers and for influencers doing the right thing as the influencers are themselves. So we are actually in a very interesting period right now in the United States because every 10 years or so, the Federal Trade Commission reviews this type of guidance and suggests updates to it. So we're actually applying right now endorsement guides that relate to influencers that haven't been reviewed for more than 10 years. And the world of social media, the world of influencers has changed. Some of the main social media platforms that we all use today were not around 10 years ago. So we're in a very interesting period because the FTC is looking at what's happened over the last 10 years and asking the kinds of questions about, well, what needs to be updated? What kinds of guidance do people need right now? And there's a lot to talk about. I could spend all morning telling you about the issues that we're thinking about. But on the next slide, I thought I would do is just give you a little bit of the flavor of the kinds of changes that people are making. So here are some of the issues that the FTC is thinking about right now. We've seen the rise of virtual influencers online, and the FTC has said they believe in their proposed revisions to the guide that you should treat a virtual influencer, a robot influencer, a digital influencer to be covered in the same way under these rules as you would any other influencer. The other thing that the FTC has said is they really believe that any promotion of a brand, any reference of a brand is likely going to be considered to be an endorsement that requires advertisers and influencers to comply with these guides. So for example, if an influencer does nothing more than tag a brand in social media, if they were paid to do it or they got some sort of benefit for doing it, that would require disclosure as well. One of the things that the FTC did say in its proposed revisions to the guides, which is very, very helpful, is what do you do about old social media posts, right? Imagine an influencer posts something for you right now. They post it on their Instagram feed. It works its way down the feed. It's now a year old. The influencer doesn't use your product anymore. The influencer is making out-of-date claims. Do you have a requirement to take down those social media posts? And the FTC said no. The FTC said, in what is honestly kind of surprising guidance, that consumers understand that when something's old, it's old. They don't know that they're not going to understand it to mean that it reflects either the brand's or the influencer's current opinions today. The FTC has also put a lot of attention on the use of consumer reviews. And this is not about taking an individual consumer review and using it in your advertising. The general rule in the United States is if you want to take an endorsement and you want to promote it, generally that's okay to do. The issue that the FTC is focused on here is when you have a consumer reviews section of your website where, like for example, you list your products and then under it, consumers can post reviews. Well, the FTC is very concerned that brands are editing those reviews, removing some of them, curating them in a way to misrepresent what the general opinions are that consumers are expressing. And so the FTC in its new guidance is giving pretty specific guidance that says, if you're going to host consumer reviews on your site, you have to host them honestly. You can't take out the negative reviews. If you're saying that you're posting all the reviews, you've actually got to do it. The FTC also said, don't pretend that someone's a user of your product if they're not. Another area that the FTC is really focused on in the disclosure side is this idea of disclosures need to be effective, which is that if an endorser or an influencer needs to explain that they've got a connection to the advertiser, you've got to make sure that that disclosure is something that users of social media are actually going to see. That the traditional disclosure standard in the United States is clear and conspicuous, which means that in order for a disclosure to be effective, it must be able to be seen, read, and really easily understood by consumers. So what the FTC has said, however, is that with respect to online disclosures, it's not enough that they're clear and conspicuous. They have to be unavoidable. And what does unavoidability mean? Unavoidability means simply that a consumer has to see the disclosure no matter what they do. In other words, if they keep scrolling in social media, if they don't click to expand the post, if they don't scroll down to look somewhere else, you have to make sure that no matter what they're exposed to with respect to that endorsement, that they also see the disclosure. And then you can see there's other things that the FTC is concerned about as well. For example, when you're hosting consumer reviews on your site, you might have star ratings that summarize the ratings of all the stars that the consumers have given you. Well, if some of those ratings were based on incentivized reviews, the FTC is saying, don't include those reviews in your star ratings because there's no way to include that disclosure in the star rating itself. Anyway, those are the kinds of things we're thinking about. The point here really is that we are really deep into the weeds in the United States about the details about influencers and endorsers, and we're really holding advertisers to a very high standard to ensure that consumers, when they are exposed to advertising, are seeing truthful advertising and that they're understanding the connection to the influencer who is speaking.
Which I think that's interesting because in Mexico, obviously one of the major problems, and I'll talk about a case that we had at the firm, is consumer reviews. At the end, nothing is regulated, so I can be a company or a consumer and I can be putting stars to my company, and obviously everybody's gonna know that my company is likable or not. But that's why we have to have, I'm not saying a legislation, but yes, guidelines that could guide us as jurisdiction in Mexico regarding these type of cases. Valdir.
Well, I already mentioned the Consumer Defense Code. It's the most important piece of legislation that regulates advertising. And basically, advertising has to be clear and not misleading, not disparaging, etc. The child and adolescent statute also applies, especially for child influencers. Can you change the slide? And the most important guideline is the one issued by CONAR in 2021. There are too many influencers in Brazil. It's very hard for CONAR to keep track of them. There are 9 million self-declared influencers in Brazil, but most of these people are just trying to make some money on the internet and looking for sponsors. But there are some very popular ones that have several sponsors. So it's difficult to keep track of 9 million so-called influencers. But what I was speaking to Susanna before the panel, and she told me that since the enactment of the guidelines, they have sent 340 letters, warning letters to influencers and to sponsors, because they were not using the hashtag publicity or hashtag ad. And most of them are complying. And also about statistics, in 2021, roughly 16% of the cases decided by CONAR ex officio or under complaints filed by third parties. 16% referred to influencers, and after the enactment of the guidelines, that number dropped last year to 12%, roughly 12%. So they're starting to follow the guidelines.
Sorry to ask you this, Valdir. So CONAR is binding? It's a binding?
No, it's self-regulation,
okay,
but the media accepts their decisions and takes down commercials and ads, and most parties involved do abide. That was just a 3-step test that CONAR uses to verify influencers' posts. the promotion of the product or service or other associated signs? Is it associated to another sign? If there is compensation or commercial relation, and if there is editorial control of the influencer's post. So we've had cases, clients, foreign advertising agencies based in London, for example, hired another agency in the US that sub-hired an agency in Brazil, hired by a distributor who was hired by the chain of retail stores, someone in that ecosystem hired an influencer, and the influencer wrote the post, submitted to the agency that hired her, but it was translated to English, and the English agency gave the green light based on the translation, but the translation was not accurate. So it's difficult for CONAR to get to the entity responsible for clearing the post, but it's something that they are improving now, and it's part of the game. Too many entities involved.
Thank you very much, Valdir. Damaso, platícanos un poquito de Argentina y lo que tienen allá.
Sí, lo interesante de lo que oímos de Jeffrey y de Magali también es los organismos que regulan la Federal Trade Commission y Indecopy son organismos que tienen capacidad de enforcement, digamos, ¿cierto? Mientras que todo lo que ya se ha dicho sobre las obligaciones del influencer, de que tiene que decir cosas ciertas, de que tiene que estar recomendando un producto o un servicio que de alguna manera lo ha autorizado y le ha ido bien, de que tiene que ser leal en la transmisión de todos los mensajes que da, todo eso nosotros lo tenemos solamente a través de CONAR, el sistema de autorregulación, que es muy eficaz, pero no es enforceable. Entonces, no soy muy amigo de que haya una ley específica de influencers, pero en ese sentido hay dos proyectos de ley que lamentablemente perdieron estado parlamentario que sí regulaban, digamos, las obligaciones de los influencers, el límite de responsabilidad, sobre todo en uno de los proyectos de ley, el proyecto 1898 del 2021, que modificaba o le agregaba unos artículos a la ley del consumidor. Entonces, de lo que se trata es de determinar cuál es el nivel de responsabilidad y cuándo hay responsabilidad por parte del influencer, cuando evidentemente incumple algunas de esas normativas. Y ahí hay dos posiciones doctrinales, una que sostiene que el influencer no está específicamente influencer o promotor o quien hace una promoción, específicamente listado en el artículo 40 de la Ley de Defensa del Consumidor, que tiene una responsabilidad solidaria, y hay otros que hacen una construcción en base a ese mismo artículo, por el cual, como ustedes saben, porque está en la mayoría de las leyes, digamos, tanto el fabricante, el que comercializa el producto o el que lo pone en góndola es solidariamente responsable por las consecuencias o daños de ese producto, y hay miles de casos en la jurisprudencia de Ley de Defensa del Consumidor en Argentina, y también la otra nota que señala que el contenido del mensaje es parte de la oferta y es obligatorio para el titular del producto que vende, para el promotor, para el comunicador, y ahí está el influencer comunicando algo que tiene que ser cierto y que lo obliga. Entonces, hasta que no tengamos un caso jurisprudencial claro y tengamos una clara definición de cuál es la responsabilidad del influencer y la extensión de esa responsabilidad, vamos a seguir todavía, digamos, dependiendo del sistema de autorregulación, que sin embargo es muy bueno.
Y la gente, bueno, tus colegas y tú empujan con la autoridad para que exista algo. Tú dices o criticas el tema de que existe una legislación, pero bueno, yo creo que el lineamiento es algo interesante para que, para la redundancia, nos guíen, ¿no?, en el día a día, para todo el tema de los influencers.
Sí, por eso, a pesar de que no soy un amante de una ley específica para influencer, porque si no tendríamos que tener normativa para todo, digamos, ¿no? Para todos los actos de nuestra vida diaria, sería demasiado ridículo, prefiero normas generales. Los dos proyectos de ley que había eran interesantes y otorgaban esa claridad, digamos, en cuanto a la extensión de la responsabilidad.
Muchas gracias, Damaso. Y bueno, en México, como les comentaba, no existe ningún tipo de regulación. Entonces, como abogados, cuando nos hablan los clientes y dicen, ¿nos pueden ayudar? Hay muchas leyes que encuadran en relación a temas de influencers, como todo el tema en el INPI, la Ley Federal de Derechos de Autor, con el tema de las reservas. Algo que es interesante es la Ley de Transparencia para temas de publicidad. Al final es una ley tan pequeña, pero tan general, que al final lo que hace es, un influencer puede ser considerado un medio. Al final esta ley lo que estaba regulando, o lo que le regula, es la relación entre medios, anunciantes y agencias. Entonces, creo que eso es para que se den cuenta cómo entran todos estos tipos de leyes. Entran leyes de competencia, entran temas de promociones, o por supuesto todas las diferentes normas que existen. Y creo que al final lo que yo sí critico no es una ley, creo que es muchísimo, como tú mencionas, Damaso. Aquí el problema es que no existe ningún tipo de lineamiento. Entiendo que con Profeco ya se están hablando, o se ha hablado para tratar de que existan algún tipo de lineamientos en relación al tema de los influencers y de las plataformas. Pero aquí el problema es que no hay un tema de observancia con la autoridad no empuja estos temas porque, por supuesto, yo creo que no tiene manos para estar atrás de estos tipos de temas. Y al final, como tú mencionas, Damaso, han salido diferentes proyectos de ley de nuestra nueva administración que al final no tienen nada que ver con el tema de los influencers. Lo único que quieren es ir en contra de temas de dinero, temas fiscales, que al final no se meten al tema de la publicidad en el día a día y, por supuesto, afecta a todas las personas que están en este medio. Bueno, y creo que, this will be an interesting part of the presentation, cases, which we're going to know a little bit about what's happening in different jurisdictions. Magali, cuéntanos un poquito de lo que pasa en Perú.
¿Puedes ponerme la siguiente o solo un ratito? Este nano se llama José Martínez. Empezó a hacer posts, no sé si a los 12 o 13. A los 16 le compró una casa a sus padres, enorme. Tiene más de 20 millones de seguidores en un país de 30 millones de personas. La mayoría de sus seguidores son niños como él. Entonces, ahora sí, vamos al case. La de atrás, correcto. José Martínez. En este momento, solo en TikTok tiene 24 millones de followers. ¿Qué hizo? Dentro de todas las cosas que hizo, solo este casito que llamó la atención. Es el que les planteo en este panel. Hizo publicidad encubierta en relación con apuestas de deportes. Entonces, ¿por qué llama tanto la atención? Primero, porque lo hizo a los 16 años, menor de edad, es una criatura. ¿Cómo lo descubre Indecopi? O sea, ¿cómo salta esto a la luz? Porque dos influencers más, dos chicas mayores de edad, soltaron con las mismas palabras que utilizaba este niño el tema de, oye, estoy haciendo un montón de plata con unos profesionales en apuestas que me están ayudando. Y esa frase la repitieron 3 influencers distintos en Lima. Entonces, ahí lo agarran. ¿Qué hace Indecopi? Abre investigación contra estos 3 influencers. ¿Pero qué hacía con este niño? Porque era un menor de edad. Un menor de edad que estaba haciendo publicidad en relación con una actividad que es ilegal para menores y dentro de los cuales tiene más de 20 millones de seguidores niños, menores, en que promovía apuestas. Entonces, llama la atención, ¿por qué? Primero porque los padres tuvieron que responder por lo que este chico estaba haciendo. Y segundo, porque del tema administrativo y de una multa que eventualmente le pueden poner al influencer, puede llegar a un tema incluso penal. Entonces, es un caso pues importante, se manejó de manera privada y me parece que en base a las otras 2 chicas que hicieron, siguen en proceso ante Indecopi.
Muchas gracias, Magali. Jeff, tell us a little bit about the FTC and the enforcement with influencers, please.
So there's been so much enforcement in the United States related to influencers that I thought I would just give you 3 examples of a little bit of how the way that enforcement is evolving recently. This is a very typical case that's up on the screen. This is simply celebrities getting on social media, posting about a product, potentially making false claims, and not properly disclosing their connection to the brand, right? So the FTC's expectation is if you're an influencer and you're posting online, you're gonna have a clear, unavoidable disclosure that says that this is being paid for by the company. Again, in this situation, they charged the company, but they only sent warning letters to the influencers. The focus was on the company here, the focus was on disclosure, but they kind of let the influencers know that they need to clean up their act too, and they paid $1 million. This is from a couple years ago, very, very typical FTC enforcement. So on the next slide, so this is a case the FTC brought very, very recently, which reflects kind of the expanding interest that the FTC has in influencer issues. In this case, the FTC went after both Google, which is the maker of the Pixel phone, the Pixel 4 phone, and iHeartMedia, which was the media company that supplied the DJs who were going to do the actual endorsements online, on their radio stations. So in this situation, Google asked iHeart to get its DJs on its radio stations to promote the phones, but they gave them specific scripts to read, and what those scripts did was they represented that they were actual users of the product. So this was not a case about disclosing the connection to the advertiser. They were clearly advertisements. The concern that the FTC expressed here was that these people weren't really proper endorsers at all because they hadn't really used the product. In other words, they were violating that first principle that I talked about, which is this has to reflect your honest opinions, finding beliefs, or experiences. And you can't talk about how you love a product. You can't say it's your favorite camera phone. You can't say it's great at helping you get stuff done unless you've actually used the phone, right? So there's no disclosure that's going to help you there. But what's significant about this is the FTC is starting to look more broadly at influencer issues. It's not simply about endorsements. It's about, are you actually telling the truth? Are you really a user of the product? And here, it's not just about going after the advertiser themselves. This is one of the very, very rare cases of the FTC where the FTC actually goes after the media provider as well for engaging in false advertising. And again, big dollars, $9.5 million settlement. Final example I want to give is a case that the Securities and Exchange Commission, and we haven't talked about the SEC yet here, when it brought against Kim Kardashian. So what's the big news here first? First, it's not the FTC, it's actually another federal agency getting into the business of going after, looking at influencer advertising. So again, what that's saying is that it's not just the FTC that's concerned, but other federal as well as other agencies around the United States are thinking about these issues and thinking about the way that their own specific standards apply. That's number one. Number two, this is a case against the influencer herself, not against the company. Now, I'm not saying there aren't all kinds of crypto actions going on as well, and people are looking into all of these in all kinds of different ways, but this is symbolic of, influencers for a very, very long time were not the focus of enforcement action. We wanted them to do things right, but the focus was really on the brands themselves, ensuring that they got the influencers to do the right thing. And this is an example of recent enforcement where we're saying, now it's time to start going after the influencers themselves. What's also interesting about this case is it's about specific SEC rules requiring a different type of disclosure that would be required. I mean, it's an important message for advertisers in the US that you can't just rely on FTC standards, particularly when you're advertising in regulated industries. You need to think about things like the SEC and anti-touting rules if you're promoting securities. So what we're seeing here in the US is it's not just about disclosures anymore. It's not just about the brand anymore. It's about anybody, including the media company, including the influencers themselves, who are participating in getting influencer endorsements out there.
Thank you, Jeff. And this, at the end, Kim Kardashian, obviously she has millions of followers, and obviously she was a big fish, and that's why the SEC wanted to prove a point there, no?
Yeah, I mean, look, Kim Kardashian is one of the most prominent influencers out there, right? She's well known as an influencer, but she was also an easy target in this case as well.
Exactly. Because at the end, she's a lawyer. She has to know about, no? Valdir, please.
Well, as I mentioned, we have very little litigation involving advertising in Brazil. Most cases are decided by CONAR. There haven't been very high-profile cases lately. And as I mentioned, they sent warning letters to the little guys. A couple of examples that show how CONAR is targeting companies that hire influencers. Some of these companies, they don't admit that they hired influencers. They just give products as gifts, souvenirs. And then the influencers post the product. They're not being paid to post, but they got the presents. So there's a gray area there. You know, if you get a gift from a company and you post it, even if you say good things about it, there's a thin line between that. So in that case, Rehappy, which is a very big chain of toy stores, hired 2 influencers to publish posts related to the stores, but the posts didn't have the hashtags. So CONAR notified both the influencers and the stores, and they had to edit the posts. So, but that's a high-profile case because Rehappy is very big. You know, the next case involves a child influencer, which is becoming more popular in Brazil. I'm going to show another example later. Helena Andrea is a child influencer, of course, represented by her parents, and probably her mom has been helping her post her posts or texts. And CONAR ex officio. In many of these cases involving influencers, especially children, CONAR is acting ex officio, not waiting for some association or like the Alana Institute, which is very active in protecting children's rights. They do it, CONAR does it ex officio. So they summoned Fun, which is not a toy brand, and Fun claimed exactly that it was a gift. They didn't pay the girl or the parents to give testimonials about the product, but the CONAR rapporteur did not buy that and advised the company and the influencer to use the hashtags, but they deleted the post, so there was no enforcement.
Bueno, este es un caso interesante que elegí por varios motivos. El primer motivo es que justamente el CONAR recientemente sacó una serie de recomendaciones para aquellos influencers y también para las empresas que contratan influencers que se refieren a temas financieros. Hay una obligación de estas empresas de educar a los influencers para que ellos estén en condiciones de recomendar algo sabiendo al menos básicamente de qué se trata. Esta es una empresa Bayo Business que ofrecía su propia criptomoneda, el Bayo Coin, con la promesa de, por supuesto, enriquecimientos exponenciales con un sistema Ponzi, con un entramado de sociedades confusamente establecidas. Bueno, fue muy publicitado, estuvo en todos los diarios, este caso muy resonado, pero en abril del 2022 la Dirección Nacional de Defensa del Consumidor inició, digamos, acciones contra esta empresa por violación de la protección del consumidor y por no probar, obviamente, clara y transparente información sobre los servicios financieros que ofrecía. La estafa y la quiebra fue por varios cientos de millones de dólares y hubo, muy interesante también, estuvieron involucrados influencers de primera línea, comunicadores como Tinelli y otros, pero muy relevantes, algunos de ellos manifestando que ellos habían tenido mucho éxito económico con estas criptomonedas que habían comprado. Y además los pagos a los influencers eran sumas elevadísimas. Bueno, además la AFIP inició también una investigación y está solicitando a todos los influencers que justifiquen que se hayan acreditado y se hayan registrado sus ganancias ante la autoridad impositiva. Y finalmente muchos de los damnificados iniciaron también una acción por estafa, por fraude, por vía penal, donde los influencers, interesante, podrían resultar partícipes necesarios. Así que es un caso que pone en tela de juicio todo, o sea, un poco CONAR da unos guidelines, unas recomendaciones, pero que después no se cumplen, y cómo terminamos con un desastre económico y cómo hacemos para hacer ejecutivo o efectivo, digamos, la pena contra este daño que han causado esta empresa Bio Business.
Gracias, Valdir. Bueno, for this particular case, it's just an example of two cases that we've seen at the firm, and I cannot put the influencer, but at the end, this is a person going into a restaurant, saying, "Well, I'm an influencer. Can I take pictures and upload them?" Obviously, they said yes, but when he left the restaurant, he didn't want to pay. So at the end, he started putting reviews, like Jeff was talking. In the United States, the FTC regulates consumer reviews. In Mexico, we don't have anything. So I can say that this company is the worst company in the world, or contrario sensu, I can start saying that it's the best company in the world. So at the end, this is so much loopholes that at the end, the FTC, the Mexican FTC, which is Profeco, just notified the influencer, and we had to negotiate with Profeco to settle in a way. Obviously, it's not millions like in the FTC, because they don't enforce day-by-day issues, but this is a clear example of why, if we had guidelines, we could see exactly how to go through each of the cases. It's interesting to say that influencers and cases related to social media, the majority of times is companies hiring us, and like I've told Jeff and the people from Gala, you have to be very clever and with a little bit of imagination to see exactly what to do. Obviously, if there's another party in the case. Regulatory advertising, like I was mentioning, COFEPRIS regulates certain products, and at the end, during pandemic, where influencers and social media was the venue to publicize in a day-by-day, they brought down different influencers' publicity, because obviously they were going against the health law established in Mexico. This was, again, COFEPRIS going against influencers here in Mexico, because obviously vaping is not permitted in Mexico. It's not regulated in Mexico, so at the end they went against these influencers because they were promoting Blue and other companies, and then the girl on top was promoting Dos Equis. Even though Dos Equis did not hire this girl, the girl did not have a permit from the COFEPRIS trying to publicize alcohol, and at the end they went. It wasn't. It was just a notification from the Mexican FDA, which is COFEPRIS. So we're going to talk a little bit about particularities of each of the jurisdictions, so the audience can see what is different in other jurisdictions. So, Magali, platícanos un poquito de las particularidades. Creo que una de las particularidades más importantes es Indecopy. Al final, Indecopy, siendo una autoridad que regula desde temas de competencia desleal, temas de antitrust, temas de marcas, patentes, derechos de autor, creo que es una autoridad que tenemos que, de alguna forma, guiarnos nosotros como latinos, porque creo que lo han hecho muy bien, siendo una economía que es
pequeña,
muy pequeña comparada
Sí.
con México, ¿no?
Correcto. Indecopy regula e Indecopy ejecuta. Indecopy te bloquea tus cuentas bancarias a las grandes empresas. No le tiene miedo, hace 20 años funciona así y es de las instituciones más respetadas en el Perú. ¿Qué hace en materia de publicidad, incluyendo a influencers? Les aplica la misma multa que le aplicaría a cualquier anunciante. Es decir, la multa puede llegar hasta 700 UITs. La UIT es una unidad impositiva tributaria en Perú que le cambian el valor todos los años. De acuerdo al último valor, la multa sería de aproximadamente $850.000. Es un montón de plata. Para la economía peruana es un mundo de plata que te multen con casi $1 millón por un tema publicitario. Entonces, te hace preguntar, si a un influencer le pueden poner una multa de $500.000, de $800.000, etcétera, ¿cuánto gana el influencer? Entonces, yo me pregunté eso al momento de hacer los slides, dije, ¿cuánto gana el influencer? A mí me ponen una multa de $500.000 y me voy para atrás. Entonces, hay un estudio, o sea, es decir, ellos hacen un análisis costo-beneficio de ese post, esos 30 segundos o 20 segundos, hacen un análisis costo-beneficio de lo que te puede pasar porque Indecopy te lo va a hacer. Entonces, si vemos la siguiente, hay un estudio hecho a septiembre del año pasado en el que esto es lo que ganan los influencers en Perú. Por ejemplo, desde microinfluencers que pueden tener 5.000 seguidores, a ver, mis hijos tienen 3.000 seguidores, es como, ¿what? Hay que chequear bien qué hacen los chicos. Entonces, uno de aproximadamente de 5.000 a 100.000 es uno pequeño, es un microinfluencer, pero te puede cobrar hasta $1.000 por un post, o sea, por una publicación, ¿no? Los mid-level, un macro-influencer o un mega-influencer que tienen más de 1 millón de seguidores. Más de 1 millón de seguidores tienen muchísimos influencers. Entonces, les pueden pagar aproximadamente $25.000 por 10 segundos.
Y que al final hay como una línea muy delgada de tú eres influencer teniendo 1,000, 500 o 1 millón. Al final creo que no hay, aquí en México pasa que
Sí.
no puedes determinar quién es el influencer porque tiene 5 millones o ustedes ahorita. Pero, ¿y esa guía, o sea, ese estudio de dónde es? ¿De Indecopy?
Sí,
Okay.
lo saco Indecopy.
Ok, es importante saberlo. Perfecto, Magali, perdón que te interrumpí. Jeff, please.
So I think the thing that I want to say here, and I thought the damages is such an interesting, issue. In the U.S., if for certain types of false advertising, the penalties would be about $50,000 per violation, and you can calculate that based on the number of consumers that saw the ad. So when you think of 50,000 times, say, 1 million consumers, that's a lot of zeros. So the potential penalties are very, very large in the U.S. right now, and the current Federal Trade Commission is seeking very, very large penalties. It is not uncommon to see false advertising cases brought by the FTC that are in the tens or even hundreds of millions of dollars. But what I really want to say here as we start to wrap this up is that in the way that, when Brian started off this morning talking about this kind of, we're going to have to rethink the way we think about intellectual property, and we're going to have to rethink about the way we think about what it means to be an author. In many ways, we're going through that same exercise about advertising regulation in the US, which is, are the laws structured in the right way? Are we giving people the right guidance? Are the rules effective? And do they make sense in the context of the current kind of, hugely influential digital marketing ecosystem? And what the FTC is kind of saying at this moment is, we think we haven't been doing that great of a job in the past. We don't think we've been that effective. We don't think our enforcement priorities have really, really changed the way that things are working, and we want to fundamentally relook at all of the guidance, all of the standards that we've been doing, and do it in a very, very different way. The FTC has expressed really significant fundamental concerns about big tech, about the whole online digital ecosystem, and is really looking at all of its guidance. You include guidance about disclosures and about privacy and about transparency and this whole concept of dark patterns, and really asking questions about whether we need to think about advertising and truth in advertising in a different way. And I think that what you're seeing in terms of the way the FTC is thinking about influencers and the sort of the granularity. You know, we've talked a little bit about jurisdictions that have no rules versus jurisdictions that have a lot of rules. And in the US, we used to really be a jurisdiction that said, we want a general standard. We want a standard that just says deceptive or unfair practices are prohibited, and we'll all figure out what that means together. We've really gone complete 180 to the point now where we're in a place where we want to say, no, we need much more prescriptive guidance about what's okay and what's not okay. And what we're seeing is not only the FTC and other regulators giving that guidance, but also really rethinking it. And I think that what we're going to see in the next several years, particularly with the current FTC, is really rethinking and reworking these fundamental questions and thinking about advertising regulation in a completely different way.
Which you bring something to the table very interesting, like privacy issues. Like everybody thinks that influencers, like here in Mexico, is just about a contract. But if I have a sweepstake and I'm using information of third parties, it's a privacy issue. If it's something that's affecting a consumer, it's a consumer protection issue. So at the end, like Brian was saying in the morning, yes, it's how we have to see how's the IP going, but at the end, it's not just trademarks and copyrights. It's all of the branches of law that are related to IP. That if you're not, if you don't know about other matters related to IP, you're gonna be a very, very limited attorney.
We're absolutely, we're touching on all of these issues, but we're also rethinking them as well.
Thank you very much, Jeff.
Oh, that's another case of child influencer, a very successful one, law-abiding. Baby Alice is a Brazilian baby who lives in London with her parents, and she became viral on TikTok, on Instagram, because her mother was teaching her to say very complex words, very difficult words in Portuguese. So I don't know why she became viral. And then the biggest bank in South America, Itaú, hired her, or her parents, and the most famous Brazilian actress, drama actress or theater actress, and both of them starred a primetime commercial, and it was a very successful case. But they abide all the rules of the CONAR and the ECA, which is the Child and Adolescent Act. Now, I'd like to talk a little bit about de-influencers, which is a new trend. It probably started in the US, and it's becoming popular in Brazil. These are people who criticize products they didn't like or services they didn't like. They're not paid by, theoretically, they're not paid by anyone. I cannot assure you that the competition is paying them to talk, to say negative things about the competing product or service. But many of them are young girls talking about fashion, products, and cosmetics. Okay? And most of them are just criticizing products. They are not sponsored by, well, they're not influencers in the sense that they're not being sponsored by any company to say nice things about their products. But in that case, the influencer just mentioned negative things about the way Selena Gomez was doing her makeup. So she was not working for anybody, as far as I'm concerned. And next.
Yep. And sorry to interrupt you. Here in Mexico, it happened that during pandemic, there was a very big French beauty company that was, it was a trending topic that they were selling products that were out of date, and that the influencer came into the equation, and the case was a trending topic. It got to the Mexican FTC, which is Profeco, and we had to get it in an agreement between the both parties. But obviously, there's no guidelines, and at the end, Profeco wouldn't have gotten the case ex officio if it wouldn't have been because the case was a trending topic. And that's how you see how relevant influencers are right now in advertising.
Well, that case involves a French cosmetic company as well, Sephora, or Sephora, as they say in the US. That influencer lives in the slums of Brazil. And there are now de-influencers and influencers from the slums because they don't use sophisticated goods, so they talk about their daily lives. And they are followed by a lot of other people from the lower classes. And she was criticizing Sephora's products, and in that sense, she was a de-influencer. But she became viral, so brands such as McDonald's, Nestle, Itaipava, which is a local beer, and Boticário, which is the largest cosmetic brand in Brazil, or chain of cosmetic stores, they hired her because these products are consumed by the people who live in the slums. So he became, so she was a de-influencer who became an influencer for the popular brands. And another trend in Brazil is the use of avatars, virtual influencers, not in the sense of digital influencers, real people, but avatars of real people. And that's a very interesting case of a TV star, a woman who had an avatar created and licensed it. The name of the avatar is Satiko. So Satiko is a digitally created influencer, and the owner of the copyright, the economic rights in the copyright, licensed to Itaú, and she became the presenter of the Rock Festival in Rio. That's another virtual influencer created by artificial intelligence for a retail chain of stores called Magazine Luiza. So her name is Lu, and she is now being used in partnership with other brands such as Adidas and Samsung, and she's perfect to be used on a metaverse, because that's what they're going to use in metaverse, avatars. And just some statistics. It's a little bit sad to see that most people follow only soccer players, including retired soccer players, stand-up comedians, and funk singers. But that's the reality. It shows the reality of the majority of the population, and brands are investing in these people that have over 50 million followers. And how many in the audience are lawyers? Raise your hand, please. The majority. And how many are advertising professionals, work in advertising agencies and creatives? So the majority are lawyers. Do you think you are influencers? Does anybody think? Oh, I think so. I think we're all influencers. We influence our clients and our students and so on. But our profession is regulated. That's the case of a lawyer who decided to quit practicing law because she's making 100 times more as an influencer. That's the only client we have who is an influencer. She was a lawyer, and she liked fashion, and she started just showing the dresses and makeup, and then she started to be hired by companies. Now she's traveling to all fashion shows in Europe, and she's very successful. She'll probably make in 5 years what she would not make in her whole career in private practice. So that's our only client who is an influencer.
We should change profession, clearly.
And most importantly, after the issuance of the CONAR guidelines, she has been compliant. So if you check all the posts, they have the hashtag publi or sponsorship or whatever.
Bueno, Damaso.
No, de nuevo, la particularidad de nuestro sistema, yo diría, tenemos una larguísima tradición y un fuerte sistema autorregulatorio que funciona muy bien para las empresas, digamos, más sólidas, más serias, pero que adolece del tema del enforcement. Y por el otro lado tenemos una legislación con normas muy diseminadas, pero sin una clara norma que establezca cuál es la responsabilidad para los influencers y la extensión de la responsabilidad. Para lo cual precisamos 1 o 2 artículos dentro de la Ley de Defensa del Consumidor que incluyan el tema de la responsabilidad de los influencers.
Gracias, Damaso. Bueno, lo que les quería comentar es lo que están haciendo mucho los influencers en México es que están obteniendo su reserva ante indautor, y creo que es una de las cosas nuevas que están sucediendo, y creo que esto les da un derecho y un valor agregado a cada uno de ellos para cuando celebran contratos con las diferentes agencias o las marcas, ¿no? Bueno, esto fue un tema de aquí en México, un tema there was a case on, sorry Jeff, this was a case in Mexico that there was influencers using or trying to give publicity to political campaign. There was not a fine against them, but yes, against the political campaign. But at the end, it was because there was no type of legislation regarding these issues. And this is just so we can finish. Is when we have a client in the firm and they tell us what to do. Obviously, because we don't have legislation in Mexico, is talking to the influencers or with the companies. Check out the publicity contracts. Check out all the copyrights, obviously the guidelines to the use of the trademark, what they can do and what they cannot do when they're doing posts. Image rights, very important, and obviously there's a very thin line between freedom of speech and hate speech. So at the end, this is like a 101 that we work in a day by day here in Mexico, because again, we don't have anything that regulates. So, no sé si tengan alguna pregunta para alguno de los ponentes. Licenciado.
Sí, buenas tardes. Es una pregunta muy sencilla. Todos los casos que nos comentaron, según me di cuenta, se da con la intervención de alguna agencia gubernamental. Me interesaría saber, a lo mejor nomás estoy de morboso, pero si algún influenciado, desengañado con su influencer y por algún daño hipotético que haya causado algún producto o algún consejo financiero, se haya ido directamente contra él, en vía quizás civil. ¿Sí? Imaginen el caso de una persona que se lastima o una persona que quiere adelgazar y engordó o una mala inversión, pero que el influenciado, así vamos a llamarlo, se le cae su ídolo de barro y se va contra él, vía civil.
En juicio no, pero sería mejor que la abogada de CONAR Brasil respondiera a tu pregunta, porque creo que hay complaints, reclamaciones de consumidores sobre posts de influenciadores, pero no tengo esa información.
En el caso de Argentina, definitivamente sí. El caso que planteé, la empresa Bayo, que tenía su propio Bitcoin, por vía penal, varios damnificados fueron contra los influencers también. Sí.
En Perú sería igual, o sea, se irían vía protección al consumidor, y me queda clarísimo que la Comisión de Protección al Consumidor notificaría de oficio a la de competencia desleal para que le abran una investigación al anunciante y al influencer contratado, y habrían probablemente 2 pronunciamientos.
At the end, Jeff, it's a civil matter, obviously, in the United States, no? So it's just something that. So no sé si hay otra pregunta. Tenemos en 10 minutos más. Perdón.
Hola, buenas tardes. Mi pregunta es si hay alguna responsabilidad para un influencer una vez que él hace publicidad, pero no de forma voluntaria, o sea, que recomienda algún producto y posteriormente recibe algún beneficio que no fue acordado. Si habría una responsabilidad para el influencer. Gracias.
Magali, si quieres empezar tú de Perú. O sea, si el influencer al final promueve, publicita algo que no tiene que estar publicitando, al final esa es la pregunta. Si tiene si puede tener algún tipo de repercusión el influencer.
O sea,
si está contratado, o sea, la pregunta es si está contratado para publicitar ciertos productos y publicita algo totalmente distinto, ¿es la pregunta?
No, una aclaración. No hay un contrato de por medio, o sea, no hay un convenio entre una agencia publicitaria y el influencer de hacerlo él.
Es voluntario, el influencer voluntariamente, sin un contrato no es patrocinado.
Así es.
Y después surge un daño, ¿qué podría ocurrir?
No precisamente un daño, sino que recibe un beneficio. Por ejemplo, puede que se trate de productos que le regalen a partir de esta publicidad que fue voluntaria y que no me dio un acuerdo ni un beneficio.
Sea, si lo entiendo bien, es que nace como un testimonio personal correcto y luego el anunciante se ve agradecido por este influencer que dio un testimonio sincero y le manda algo, o sea, le manda un canje de pronto,
correcto,
como
sí,
agradecimiento.
You know, one thing I would say here, though, is that the law is actually quite different around the world on how you would deal with this issue, right? For example, in the United States, you know, if you provide any benefit to an influencer, even if there's no contract, you just give them a free product, you invite them to a party, you look at them nicely, you might be responsible for what the influencer says, even if the influencer has the ability to say anything they want. And in fact, the FTC has said very clearly that if you give an incentive to a consumer to post a review, even if the consumer is free to post a negative review, you're still responsible for what the consumer says. On the other hand, in the UK, the rule is the opposite. In the UK, the rule is that if the influencer is free to say what they want, then you're not responsible for what they do. So the rule is really going to change, you know, depending on where you are around the world. Another interesting question is what happens when the relationship with the influencer ends, right? You give the influencer a free product and they post, you're responsible. But what about a year later when they post again? You know, are you responsible for them? We don't really know the answer to that question.
Por ejemplo, yo sigo a una chica peruana, regia estupenda, que me imagino que vía canje le dieron una Porsche Cayenne. Yo decía, por Dios, increíble. Y ella todo el tiempo, me queda claro que es publicidad, pero dice las maravillas de la Porsche Cayenne, etcétera. Claro, a mí me provoca comprarme la Porsche Cayenne. Entonces, ¿qué pasa si ella simplemente se lo hubiera comprado con su plata? Y menciona constantemente en sus posts las maravillas del auto. ¿Qué pasa si luego Porsche le manda algunos regalos, etcétera, y resulta que tiene fallas de fábrica y causa accidentes? ¿Tiene o no tiene responsabilidad esta chica? Con tu pregunta me surgió ese tema del Porsche Cayenne. Creo que sí tendría algún tipo de responsabilidad porque es una persona pública, si es que se puede considerar, y pues está haciendo uso de la cantidad de seguidores que tiene, está publicitando todo eso. Si para colmo recibe algún tipo de contraprestación de la otra parte, así sea posterior, creo que de acuerdo a normas generales...
La contraprestación hace un vínculo entre la empresa y el...
Hace un vínculo, claro, posterior. Posiblemente ella podría decir, esto fue un testimonio sincero, pero sí, generó un vínculo y va a haber una responsabilidad.
Y hay otras implicaciones también con productos regulados. La Ambev, que es la más grande cervecería de Brasil, del mundo, con los belgas, regaló a una influenciadora cervezas y ella postó en la internet, pero ella tenía más de 25 años, pero parecía menos, y eso es en contra de las reglas de CONAR, no puede parecer tener menos de 25 años. Entonces, la compañía no pagó para la influenciadora postar, pero fue también responsabilizada por el post.
Gracias. No sé, doctor, la última porque nos vamos a subir a comer, vamos a tener que...
Ahí, gracias. Mi pregunta es respecto a puertos seguros, ¿no es cierto? Safe harbors. ¿Hay ¿hay alguna posibilidad de que en sus países puedan iniciar acciones en contra de influencers que son de otros países? Ahora vemos que Neymar, por ejemplo, tiene más de 250 millones de seguidores, más allá de la población de todo Brasil. Entonces, sus países pueden iniciar acciones desde Perú, por ejemplo, en contra de Neymar y de compañías que incluso no están domiciliadas en alguno de sus países. ¿Qué hay acerca de esto?
Es un tema de jurisdicción, me parece, ¿no? Depende de dónde se produzca el daño. Si el daño se produce porque es un seguidor que lo sigue en un .com, pero es en territorio argentino, podría haber una acción. Pero es más un tema de jurisdicción, me parece.
Well, I think it's a great question, and it's one that we spend a lot of time about when you think about influencers that are important influencers to different audiences. I think that I agree with Damaso that you're going to look at where the damage happened or where the advertising. The way I guess I would ask the question is to where is the advertising directed? So, if I've got an influencer in Mexico speaking in Spanish who is really, advertising a product that's available in Mexico, there is virtually no likelihood that the U.S. is going to have jurisdiction there, even if the company is based in the U.S. On the other hand, if the influencer in Mexico is speaking in Spanish but is also talking to a Spanish-speaking audience in the U.S. and is clearly direct and is clearly part of that is part of the campaign, I think that you could have jurisdiction. I have been involved in a case in the U.S. involving influencers outside of the United States where those kinds of questions were asked, and a lot of what it got down to was what was the purpose of hiring those influencers? Who were they talking to? Were their posts really directed to a U.S. audience or not? But I think it is an issue that we're going to have to pay more attention to, particularly because of the standards are different. I mean, in terms of what kind of disclosure is required, but even the effectiveness of the disclosure, right? A disclosure that you might use in Japan is not going to be effective in the U.S. So when you have an influencer who's actually speaking to more than one audience, you have to think about sort of the multi-jurisdictional compliance approach as well.
One concrete example that is very current is the sports betting companies. They are not fully regulated in Brazil, and they have become the #1 sponsor of soccer teams and soccer games and soccer players. And you see their brands in all stadiums nowadays. Suddenly they showed up. And none of them are domiciled in Brazil. They're all in Malta and Gibraltar, and they don't pay taxes in Brazil. They're making money in Brazil. They are not paying taxes because they're based in other jurisdictions, in tax havens. And they're hiring Brazilian soccer players as influencers, several of them. Marcelo, Neymar, Vini Jr., all of them. They're making a lot of money outside because they're playing in Europe, and the companies are based in tax havens. So this has to be regulated because it's totally irregular, and it should be regulated.
Because, like in our countries, that's going to be very difficult to file a complaint. In the United States, they are very nosy, and at the end, it happens that in the United States, because of political points and contact points, you get the case because you have jurisdiction. Imagine, you were mentioning, they're talking to a Hispanic audience. The product is sold in the United States. The product is a very well-known Latin product in the United States, but they're in Mexico. Maybe it's on a case-by-case basis in a way, but obviously in the United States, maybe there could be enforcement. In our countries, that's impossible. No? First of all, how you serve the other party. No sé si tengan otra pregunta y gracias a todos por su tiempo.